Hi, I'm Jeff Teichert, and I'm here to talk to you about the settlement of legal disputes. Settlement is generally preferred to going to trial for a couple of reasons. First, because it leaves the parties in control of the outcome, and they get a say in making sure that they have an outcome that they can live with, whereas when you go to trial, you're kind of rolling the dice. Secondly, it saves a fortune in costs and attorney fees. So when you can settle a case, it's better to do that. However, I have two pet peeves about settlement. The first is when the opposing counsel calls me up and drones on and on about the relative merits of their case and the relative weakness of mine. No competent attorney falls for that. By the time I have a case that's been filed, I've researched the relative merits of my claims and theirs, and I've taken a good look at the facts. Now, if you think there's something I've overlooked, either in the facts or in the way the law applies, or if there's something that I don't know about the facts, please put that succinctly in a letter and I'll consider it. And sometimes that's even useful to show my client and say, you know, you ought to think about the fact that there is another side to this. But on the whole, calling me up and browbeating me about how bad my case is not only ineffective but irritating and disrupts the working relationship between the two attorneys. The second pet peeve I have is when opposing counsel refuses to think outside the box and is confined by the legal issues in the case. There may be things that you could propose that aren't strictly on the table when it comes to the legal dispute, but nonetheless would be helpful in resolving things. For example, one party might agree to buy more product from another party at extremely favorable terms. Another idea might be two adjoining property owners having a dispute might exchange pieces of each other's property or exchange access easements or something else that they're not legally required to do, but nonetheless helps both of them to achieve their objectives. Now, I don't know how many times I've proposed creative solutions like this, and opposing counsel has simply met that with, a court's never going to order that. Or I don't think that my client's legally required to do that. Well, of course. But it may be a way through the impasse and a way to give both of our clients what they need. And so, if you're a brand new attorney, I suggest that you learn to look for creative win-win solutions for your clients and for the other party. And I think you'll serve your clients best by doing that. If you're a party that's in a dispute, look for a creative attorney, someone who is able and willing to fashion solutions to problems rather than just fight. Now, don't get me wrong. Sometimes you've got to tee it up. I can go to court and I can write briefs and I can do all the other things that I need to do to win a lawsuit with the best in my profession. However, I also realize that too many attorneys are simply giving up at the first sign of an impasse rather than really pursuing a solution that would be best for their client.